Good evening. My name is Kellon Rover, and I'm here with the Attorney General and Minister of Legal Affairs, Senior Counsel, the Honorable Anil Nandlall. Good evening, Minister,
Thank you very much. Good evening to you and your viewers.
and thanks for being here this evening with us. Minister, before we get into the main reason for this interview, um, how are you doing this evening?
I'm fine, thank you, and I'm happy to be here and to clear up some misinformation that is being peddled out there.
Great. So I know, of course, as you said, you were here to clear some misinformation that are in the local newspapers. This is concerning the government's recent move to the Caribbean Court of Justice to reverse the decision of the appeal court refusing to add the government as a party to the unlimited guarantee case. Minister, could you explain why the government wants to be added to the case? That's after you would have provided us with the genesis of the issue.
All right, so there is so much misinformation out there that we need to address. And if you will permit me to digress a little from your question, to give a historical backdrop of the type of litigation that we are referring to. Now, you would have observed, and the people out there are aware, that a number of cases have been filed by a number of citizens in relation to the oil and gas sector. They have challenged various aspects of the operations in that sector, including the contract itself, the license, and the execution of activities in the sector. Now, they are able to do so under a legislation that was enacted by the People's Progressive Party civic government, the Judicial Review Act. That act needs to be explained. The first point I want to make, which I've made already, is that the act was passed under our government and by our government. You hear a lot about transparency and accountability in government. This piece of legislation is intended to make it easy and possible for any citizen to file cases against any actions or decisions of a government, a minister of the government, a public officer, a statutory agency, a public corporation, or a governmental department. Across the spectrum, you can challenge any decision. You can go to court and complain that the decision is wrong in law, that the decision was made in breach of natural justice, that the decision is against public policy, that the decision is illegal, that the decision is unreasonable, that the decision is irrational, or that it is discriminatory in its nature. So there is a wide platform upon which you can challenge actions and decisions of any operator exercising lawful powers on behalf of the state, including the entire government.
Right.
So that's the first thing. And that is a demonstration of our government's willingness to make itself accountable and transparent in its operations and in its day-to-day conduct of the affairs of the state. We are not afraid of scrutiny. This legislation also allows for a number of orders to be made against the government if the decision is found to be one that is wrong in law. Compensation can be awarded, the decision can be set aside or quashed or declared a nullity. Any form of injunctions can be granted, orders mandating the government to take corrective measures, orders prohibiting the government from continuing that particular type of action. As I said, damages in the form of compensation can be awarded, and a whole host of remedial orders can be granted under this legislation. The other point that I want to make about this legislation is that when you compare it with similar legislation in the entire Commonwealth, including the entire Caribbean, you would find that ours is the most liberal of the type of legislation, in the sense that in almost every other country in the Caribbean, at least, one has to get leave of the court to file proceedings of this nature. What does that mean? It means that you can't automatically file these proceedings. You have to go to the court first in a preliminary application and make out what is called a prima facie case. And then the court grants you leave or permission to launch the judicial review action. In Guyana, we have removed that leave requirement. So you can file a case immediately. The other point I want to highlight about our legislation is that it allows any citizen to institute legal proceedings. And it allows for any citizen who claims an interest to be joined in those proceedings, without exception and without limitations and restrictions. So we have the most liberal judicial review legislation in this part of the world that allows the citizens of this country to challenge any action or any decision made by the government and those who are in authority in the state apparatus. The PPP gave the people of Guyana that right. Why? Because we believe that our actions must be subject to scrutiny, judicial scrutiny and public scrutiny. And if the citizens feel aggrieved by these actions, they have a right to approach the court. And we have made that right very accessible. So I want to underscore that point. Right. Now, that is the legislation that is being used to launch all these proceedings. We are not complaining. We put that in place for this to happen. The other point I want to make is that when we pass this legislation, it had to be brought into force by the subject minister, who is the Minister of Legal Affairs and Attorney General. When we enacted this legislation, we didn't have the requisite rules of court in place to accompany it. And before those rules came into force, we lost the government in 2015. Attorney General Basil Williams was written to by me after the relevant rules of court came into force, was written by me requesting for him to issue the order to bring that law into force. He refused. I then filed legal proceedings against him in my own name. I was the litigant and the lawyer in the matter. We were in the opposition. He lost the case in the High Court. He then appealed to the Court of Appeal and he lost it again. And still yet, he refused to bring the act into force. I then filed contempt of court proceedings to commit him to prison for not bringing that act into force. He then complied because I got orders of the court compelling him to bring the act into force. So when you hear that the PPP is, or the PPP government is acting in secrecy and is afraid of transparency and is afraid of accountability, it cannot be true. If we passed a legislation of the type that I am referring to, and we didn't only pass that law, we established a court in tandem with the judiciary,
Right.
a special court to hear and determine these matters. It's called a Constitutional and Public Law Court, where these matters can be heard expeditiously. You don't have to join a long line. These cases are not going to be put in a bundle with other cases. They are going to a specialized court so that they can be heard and determined quickly. Now, is that the behavior or conduct of a government that is afraid of accountability and transparency? Certainly not. So, all these persons, they have no interest, direct interest in the oil and gas sector. But because of this legislation and because of its liberal terms and the liberal language in which it is constructed, it allows every Tom, Dick, and Harry Lal to file cases, although they have no direct interest in the oil and gas sector.
Correct.
Now, this case was filed in relation to the financial assurance that was not lodged by the oil company. The state was not made a party. The government of Guyana was not named as a party. Now, the Environmental Protection Agency alone was named. Let me say, first of all, that the Environmental Protection Agency is not a government agency or department. It's an agency of state. It's a statutory body. That's different from the government of Guyana. Now, that case had the potential and has the potential to shut down the whole oil and gas sector. Because the contention in that case was that there is a legal requirement for a guarantee or some form of financial assurance as is required under the Environmental Protection Agency Act. And the operations are going on in the oil and gas sector without this assurance being in place. As a result, one of the possibilities is that the license can be revoked.
Right.
If the license is revoked, the operations will have to stop. Now, these operations, as you know, is under a contract between the government of Guyana and the licensees, Exxon and its affiliate companies. They are on one side of the agreement and the government is on the other side of the agreement. This is the infamous 2016 agreement signed under APNU AFC. So the government is a party to the contract. This environmental assurance, the financial assurance, that is a requirement of the license and a requirement of the law, is also a condition in the contract of which the government is a party. Now, the government of Guyana draws a significant sum of money in terms of revenue inflow from the oil and gas sector under that agreement. We have said a million times that yes, the agreement is lopsided, but it is the agreement that we have to work with. We can deal with the terms of the agreement later. Now, if I am a member, if I am a party to a contract, and I am to get significant revenue flow from this contract, you would know, and the entire world knows, that our budget, for example, has increased significantly because of the revenue flow from the oil and gas sector. You know that Guyana is under physical, economic, financial, and social transformation, largely driven by revenues that is being derived or that are being derived from the sector under that very agreement. All the physical expansions taking place in the country, all the infrastructural work taking place in the country, all the highways, all the bridges that are being built, all the hospitals, all the housing drive, etc. This oil and gas contract is connected to all of that, and the revenues from this sector is connected to all of that, or are connected to all of that. In other words, this sector is critical to the public good and critical to the developmental agenda of our country. So not only are we a party to the contract itself, but Guyana and its people stand to benefit significantly from this contract. The government is a party to the contract, as I said. How can you take a case to the court in relation to this contract, in relation to operations under this contract, in relation to the license issued under the contract, and you are not naming the government as a party? How can you challenge the legality of the contract, challenge the legality of the operations on the contract, operations under the contract, possibly shut the operations down, and the government that is not only a party to the contract, but is a significant beneficiary of revenues flowing from this contract, which the government intends to use to develop the country for the benefit of its people, that very government you don't want to be heard. Where is the accountability? And who lacks the transparency here? This is basic law, basic natural justice, basic fairness. You want to decide a whole case in relation to this sector, and you don't want the government to be heard? The government that is a party to the contract and that has to benefit so much under this contract?
But AG, can that be deemed unlawful?
So, I'm getting to the case, and I'm going to deal with all of that.
Okay.
So they file these proceedings. So look at the unfairness. This same government passed this law that allows the whole country to file action against the government and against state actors and state players. The Environmental Protection Agency is one. So the law gives them an interest and allows them the ability and the capacity to file. The law passed by the government.
Right.
But the very government now, who has an interest greater than any one of them or all of them combined? An interest based on contract, an interest based on revenue flow, an interest based upon developmental agenda, and upon so many other grounds. And you don't want the government to be heard? And that's what the case is about. So they file the proceedings. They have an interest, but the government must not have. And the government must not be heard, but they must be heard. They filed the case in the High Court. The judge ruled in the way that he did. The government was not made a party. When I was informed of the case, it was already very advanced, and you couldn't join the case at the time. Then the judge made the ruling of an unlimited guarantee, which is an unknown animal, both in the commercial arena, in the insurance arena, and in the legal arena. You can't insure an interest whose liability is limitless. All of them who are criticizing, let them go and get an insurance policy to insure a risk that has no limitations. And the Environmental Protection Act itself, which requires this assurance, expressly says two things. One, it must be to the satisfaction of the state. This assurance is not to satisfy the judiciary. It is to satisfy the state. Who is in charge of management of the state? The government. So the government has to determine what that insurance or assurance will be. The environmental agency is the agency to secure it. But it must be to the standard of the government. That's the first thing, not the judiciary. Then, obviously, it can be limitless. It can be unlimited. You will never get an insurance coverage for a risk that has no limit. It is such a preposterous concept that you only have to state it to reject it. So that's the problem with the ruling. Now, let me explain. This is only a financial assurance. This doesn't mean that if there is an oil spill tomorrow, that this is the extent of the compensation that the country would be entitled to. There's a total misconception. This is money that is going to be lodged to cater for that. But it doesn't mean that it is the limit. The law of Guyana and the law that governs these contracts and the law that underpins the Environmental Protection Act, or the principle that underpins that act, is that there is a polluter pay principle. That's the first principle. So if you pollute, you pay for what you pollute. You also have the law of negligence, where if you act negligently, you are responsible for all damages which flow from your actions. That's basic law. So this misconception that people have out there, that if it is it's only a $2 billion guarantee we have now. Yeah, that's like only a guarantee. That doesn't mean that we can't get more. Whoever is responsible for the wrong, the law says that you must remedy all wrongs that flow from your actions. And you must pay compensation, whatever the sum is. There is some misunderstanding out there that we are fighting. Here was the myth. The myth is that we should be fighting for the unlimited guarantee. How can we fight for something that is impossible? We have a government to run. We have made promises to the people of this country. We have to behave responsibly. The people of this country expects their lives to be transformed or at least improved. They want the country to develop. We have that duty. that oil and gas sector is critical. If you impose a requirement that is a financial impossibility and a legal impossibility, then the sector will shut down. The licensee can't operate because they can't meet this demand, because you're demanding something that doesn't exist. So I want to make that point very clear. So when the case was filed and the judge ruled in the manner that he ruled, as I said, we were not part of the proceedings. The matter was appealed by Exxon. And we attempted to join the appeal. Now, any person who is affected by any legal proceedings can join at any stage. We gave the Court of Appeal cases from all over the world to show that a party can join, including Guyana, can join an appeal if the party's interest is likely to be affected by the outcome of that appeal. That's basic common sense. And I believe we clearly established by evidence how the government of Guyana will be affected. And we asked to be heard. And we asked to be made a party. And the Court of Appeal said no. The Court of Appeal said that the EPA can represent the government's interest. As I said, the EPA is a regulatory body. Right. They are independent of the government. They regulate the government itself. We are not part and parcel of the same thing. They have their own interest to advance and canvass. Government has a different interest. Government is a party to the contract. How can you have litigation about a contract and shut out one of the parties? So under the new Petroleum Activities Act, we have inserted a provision that these cases, when they are filed, the state must be made a party. Because one of these sectors can be shut down and government is not heard. Look at, we have the Demerara Harbour Bridge, for example. Let us say one of them file a case to say that the Harbour Bridge is an environmental hazard and they only sue the EPA. And the court makes an order shutting down the bridge or shutting down the construction. Who is a party to that construction? The construction is between the contractor and the government. And you can possibly hear a whole case, shut down the construction of the bridge, and you're not hearing the government. And we are not an ordinary party to a contract. We are the government of Guyana. So it is unthinkable that you would not want to hear the government. So the principle is much more critical than the case itself. It's a larger policy principle. If the government doesn't appeal, and that's what the government has appealed to the CCJ, if the government doesn't appeal this decision and allows a precedent to be left, then cases can be filed and so many things can affect the government's interest, and the government will not become a party. And adverse decisions can be made, shutting down important projects and plans of the government, affecting thousands and tens of thousands of our citizens. And the government is not going to be heard. So the principle of appealing the decision is larger than this case. It's about the right of a government to be heard in a case that affects the public interest and affects the government interest directly. They say that I file the case secretly, my friend, or I file the appeal secretly. There's only one way to file an appeal. And the procedure is set down in the rules of the CCJ. If it is an appeal court matter, the way Guyana Court of Appeal, the rules in relation to the Guyana Court of Appeal tell you how to file an appeal. The rules of the Caribbean Court of Justice tell you how to file an appeal. And we file it in compliance with the rules. So I don't know how it becomes a secret issue, where the secrecy comes in. I see one commentator write a whole page in one newspaper today that I filed the appeal in the darkness of the night. It was filed during the day. And it was filed using the conventional method of filing appeals. Now, perhaps I don't know that I have a duty to give somebody in the press an appeal that I file. Reporters know how to get cases, how to get legal documents. They have been doing it all the years. One newspaper owner feels offended that the Attorney General did not give him a copy of the proceedings. I don't owe any such obligation to any reporter or to any news agency. The government doesn't owe that obligation to anyone. There are ways by which you can get documents. These documents are public documents.
Right.
Go and get them. I owe you no obligation to send cases to you that I file. And why am I going to send it to you anyhow? You're going to write one set of foolishness about it, as you are doing. So, that is the complete, I see all manner of ridiculous allegations and accusations being made against me and the government in relation to this matter. And they are unfounded, they are misconceived, and they are wholly wrong. Any government finding itself in this position, or any citizen whose interest, contractual, legal, or of some other nature, is affected by a proceedings, have a right to be heard in those proceedings. And if they file and they are refused, they should appeal. That is all the government has done. That is all the government has done here. And you find this hysteria in the public domain, peddled in certain quarters of the press.
And AG, if I may ask, there are some people who are accusing the government of siding with Exxon to protect its interest as opposed to the nation's interest. Could you speak to that narrative?
That must be rejected in the strongest possible way. We, from the time we got into government, first of all, let me say that we have recognized the unfairness of the current contract while we were in opposition. From the moment, it's the People's Progressive Party in opposition that disclosed that contract because it was hidden for over a year. That contract was signed in 2016 and was not made public till 2017, over a year. The signing bonus that they hid, it is we who made it public as well. When Jordan with a straight face says that he's unaware of it, and we saw a letter signed by him directing the opening of an account for the money to be deposited in. And he lied and said that he doesn't know about it. And then, of course, he said he thought it was some private donation or some foolishness like that. So, from the moment we got into government, we have done a number of things to protect the local and the people's interest. One, we passed the local content legislation.
Right.
No other country in this hemisphere has a legislation like that. We went to Africa, we went to Norway, and we looked at different models. And we fashioned it to meet our peculiarities. They had people right here in Guyana who wanted to challenge the government on that. They wanted to challenge the government, saying that it will collide with the revised Treaty of Chaguaramas and all sorts of things. And we went ahead and we passed that to protect Guyanese interest. In that legislation, Guyanese companies must be accorded priority in a whole set of matters.
Right.
And Guyanese companies, we ensured that we drafted the legislation in such a way that you can't come through the back door. So not only must you have a Guyanese shareholders in a company, Guyanese must actually be in the management of the company. I think 80% of the management of the company must be Guyanese. You don't have that any part of the Caribbean. We put that in place here to ensure that Guyanese get jobs and Guyanese are allowed to participate, not fairly, but given priority in the sector. You know what APNU AFC recommendation was? They wanted to limit the definition of Guyanese to only include local Guyanese. And I want the people who will be watching us from the diaspora to understand that. They wanted to cut out the entire diaspora. They wanted a limited definition of Guyanese. And we had to point out to them that that can't fly, because Guyanese has a definition in the Constitution. And if you pass a law and you limit Guyanese to only Guyanese living in Guyana, then that law is unconstitutional. The people, Guyanese who are living overseas, must have an equal right to participate in the activities of their country of birth.
And how impactful is that as you're on the topic?
Hundreds of millions of dollars, hundreds of millions have been generated as a result of that local content legislation in the local sector,
Right.
in the local economy, by Guyanese. Thousands of persons are employed directly and indirectly because of this. I could talk about the training that we are training
Right.
Guyanese to become more equipped. Because remember, this is a new sector.
Right.
If we didn't have a local content law, the oil companies, they walk with their whole a whole army of workers. They don't really would like to take local people, because the truth of the matter is that we are not trained in the area. We are not trained, and that's why there's a sliding scale. Only if they can't find Guyanese, then they can import a foreigner to work in a particular sector or to perform a particular service. All of that is in the law. And we are building capacity. That's why we have an oil and gas training institute being established. And we have the Gold Scholarship Program that is dedicatedly directed, or a component of it, towards training our people to make them ready and prepared to participate functionally and fully in the oil and gas sector. So that's the first thing. Secondly, we promise that we will change the law to ensure that we don't have the type of lopsided agreement that we inherited from the APNU government. And we passed a new Petroleum Activities Act. Now, I have not heard any criticism against that act. We sent it out for public consultations.
Right.
All these enlightened people that keep filing these cases against the government and against the sector, all these enlightened people, we had public consultations. None of them made a contribution. None of them made a contribution. That act now lays down a statutory framework that will ensure a fair contract being negotiated by law. We didn't leave it to government's ability. It is now enshrined in the law and in regulations what terms must be stated in new oil contracts to be executed. So there's a second, and it has a whole set of obligations on oil companies when they're operating here, dealing with cleanup, etc., and so on, right? So there's this second thing. The third thing is we passed a Natural Resource Fund law, a new one. APNU had passed one although they lost the government, they passed one by themselves in the parliament. We learned about it afterwards. They kept parliament by themselves and pass their own law. Anyhow, so we have this new act that enshrines the principles of transparency and accountability in relation to financial inflows from the sector. That act tells you where the money has to be deposited and how it reaches Guyana. It first goes into the consolidated fund, and it has to be out of the consolidated fund. It got to go back to the parliament for the parliament to approve it
Right.
before it goes into to expenditure. And secondly, the act tells you in what for what purpose you must spend this money. So you can't spend it for luxury items. You have to. There are a list of projects that the money must be used for. Then you have a whole system and architecture within the act that allows for oversight. You have two sets of oversight. You have a board, and then there's another layer that oversights the operations of the act. If the Minister of Finance doesn't disclose receiving this money,
Right.
there's a jail term of nearly 10 years or over 10 years
Right.
to which he's liable. You have the Auditor General who will audit this fund. And the Auditor General, if he feels that that's an independent office, if he feels that he is ill-equipped to do the audits, he can hire whoever he wants to assist him in doing the audits. So that model, our legislation, has been commendably commented upon by international agencies such as the IMF, the World Bank, etc. All these reports are out there. A gentleman from Barbados, I think, wrote a beautiful article on the bill when it was in the form of a bill. So we have all of these things in place. Now, whose interest are we protecting? Any of these things are protective of ExxonMobil's interest or Guyana and Guyanese interests? Tell me. We are drafting oil spill legislation now. Whose interests are we protecting? We are drafting environmental legislation now. Now, these things takes time. It's a new sector. We are only in government 4 years now. How much can you accomplish in 4 years? Look at how much we have already accomplished.
Yeah.
I mean, I know the population is impatient and we would like to deliver at a much greater pace. But there are limitations upon how much one can do. And we have done, it's a work in progress. We will continue to strengthen our position so that we can continue to get the best possible deal. We already have been handed a contract that is burdensome. I described it when we were in the opposition as the most lopsided contract I've ever seen. That position still obtains. But you have to play the game with the cards that you have been dealt. You can't change the contract. Everybody wants the contract to be changed. Now, a contract is a legal document. How do you change it? How do you, if people can extricate themselves from contractual obligations, then what will be the value of a contract? There are grounds upon which you can change a contract. Illegality, duress, fraud, undue influence. Those are not factors that operated under the previous government. They signed that voluntarily. They negotiated that and signed that. How do you extricate yourself from that? And, they tried to do that in Venezuela, They tried to do that in Venezuela, and you see where Venezuela is? You see the problems that they have caused? They nationalized the oil companies. They took away the people's property and nationalized it. And that's what's happening there now. You see, 8 million refugees. Venezuela is banned and sanctioned internationally. Those people who are advocating for that to happen here wants to push us in that direction. That's what they. What else? What is your other explanation? They don't understand these things. If you are to change contracts unilaterally, who will want to come and invest in your country when they're not sure if they sign a contract with you tomorrow and the next day you wake up and you don't like the contract, or another government comes into office and doesn't respect the contract, or is free to toss the contract aside and don't comply with the obligations in the contract. I mean, where does that leave you as a country? Who would want to come and do business with you? Look at the level of interest that is being shown in Guyana today. We have 10 five-star hotels under construction. We have interest being expressed by large investors from every corner of the globe. You know why? Because they feel comfortable. They have confidence in the government. They have confidence in the country. They have confidence in the laws. They know it's a government that will not unilaterally change contractual deals. And who is going to benefit, or who are going to benefit from all these investments eventually? Not the people of Guyana. Who? So whose interests are we protecting, if not the people of Guyana? Name one thing that we have done. Name one thing that we have done that one can say that we are siding with ExxonMobil to the detriment of the public good or to the detriment of the Guyanese people. Cite one example, and I will deal with it now. But you have certain legal parameters within which you have to operate. We are not a rogue government. And those who think that we are doing it wrong, well, they can win the election, they can go to the electorate and they can let the people elect them, and they can perhaps do it a different way. But we are doing it in accordance with law and in accordance with democratic traditions and democratic principles. And we are governed, and we govern by the Constitution, by the laws of Guyana, and by the principles of transparency and accountability. If we don't if we don't mirror the views, or if we don't do things in accordance with the expectations of a few, well, then so be it. We can't please everybody. We are acting, and I believe that we are, in the nation's interest. And the people have confidence in us. Because we went to them with a manifesto. And we said to them, this is the promises. These are the promises that we will implement if you elect us to government. They read the manifesto and they were approving about it. They approved it because they went out and they voted for us and they put us in government. And we are now duty bound to discharge those manifesto promises, to implement those programs and plans which are in that document, which we contracted with the people to implement, because they voted for us to do that. And those are the people whose interests we have to ensure that we represent and we protect. Not this privileged few.
All right, AG. In closing, what would you say to those people who are still peddling misinformation concerning Guyanese not benefiting from the oil revenue, despite so many projects, infrastructural projects, and programs and policies implemented?
It's that question is another program by itself. But right, you, as I said, we have a manifesto that we are implementing. In fact, we have surpassed many of the promises in that manifesto. We are doing much more. Look at the scholarship program. We have surpassed in the fourth year the number of scholarships which we promised. We are going to achieve the number of housing projects that we promised in the manifesto long before the 5 years would have been completed. So we have to continue to deliver to the people. We have to continue to explain, as I am doing, and hopefully people will understand. There are a group of people or a set of people whom you will never be able to please. They are inherently opposed to everything that the People's Progressive Party government will ever do. So you know that you can't get their approval for anything. You're hoping that you can persuade more and more people that your actions are reasonable, are lawful, are in the best interest of the people of Guyana and in the best interest of future generations. That's all that we can hope. And we work every day to ensure that we get it right. We are not gods. We will make mistakes. I don't pretend at all to be anywhere close to perfection. None of us in the government. So we are going to make mistakes. And hopefully we recognize them and we correct them. But, these engagements will have to continue to end or not end, because you will never be able to end it, at least to discourage this dissemination and to clarify when there is dissemination of misinformation, to clarify them as quickly as possible. And that's why Sunday afternoon I'm here. Because when I look at the landscape of information out there, and many ministers call me and other people call and said, look at what these people are saying. You got to go and talk about it and explain what's the government's position on this matter. And so that I hope that I have done a reasonably good job in clarifying these issues.
All right, then. Thank you so much, Minister, for your time.
Thank you very much for
And to
having
our
me.
viewers, special thanks to you. My name is Kellen Rover Singh. Have a blessed remaining of the evening. So,
How was that?
it was good.
Huh?
Perfect.
What's the description, man?
What is good?
Some good lash, man.
Yeah.